So Madam Gifty says she has bought a land before. Madam Gifty, what shows that it is yours? What's the process that you went through? What's transpired? And then what shows that it is yours? So let me listen to you, Madam Gifty.
Okay, so there were some documentation, change of ownership. Then I had witnesses from my side, and then from the side of the one who sold the land to me. We involved surveyors to come and yes. And then after that, we went to the chief. We took the documents to the chief, and then the chief signed.
Okay.
We also went to the court for some stamps and then signing.
Oh, I see.
Yeah.
So, did you involve land commission?
Okay, so this 10 I'm talking about is in the north. And
Okay.
so maybe at the regional level.
Mm-hmm.
And I think the surveyors would have, that one would have been embedded in the surveyors processes or the local court processes.
Oh, okay. Okay. I see. I see. All right. So I think that is a fair idea about the processes, or let me say the procedure involved in the acquisition of a land. So this brings us to what we are coming to discuss today, which is called land law. The original name is immovable property. Immovable property. However, we sometimes shorten it and then make it land law, because in Ghana here, the immovable property specifically, we pay much attention to the land law. So if I use the land law for the purpose of our discussion, don't be confused. It's the same as immovable property. After all, the Interpretation Act also talks about that immovable property means land. So please, Section 46 of the current Interpretation Act 2009 Act 792. Section 46 of the current Interpretation Act 2009 Act 792. It actually defines immovable property as land. Immovable property as land. So after all, if we also name our topic as land law, we are not wrong, because if we name our subject or our course as land law, we are not wrong, because even the Interpretation Act, Section 46, Interpretation Act 2009 Act 796, this Interpretation Act repealed the Interpretation Act of 1960. It repealed that. So if we talk about land law, it means we are not out of context. We are still within the scope of immovable property. So the repealed one, that is Interpretation Act 1960, in fact, Section 32 was the one that specifically explained land. Section 32 of the repealed. In law, when you say repealed, it means that it has been squashed, it has been taken away, it has been put aside by another act. So Interpretation Act 2009 Act 792 has repealed the Interpretation Act 1960. So that is how it is. Don't be confused. We are now coming to start, so don't be confused. But before we start land law, let me bring it to bear something that you have to know before the course itself starts. Now, casting our mind back when we were learning law of contracts, that was yesterday, 26th of February 2024. I told you that law of contract is specifically, okay, which type of law is that? Is it case law or statute law? What did I say?
It's a case law.
It's a case law. Good.
Yes.
So, nice one. So, we realize that contract law is a case law. Now, when we come to land law, the first thing you should put at the back of your mind is that land law is a statute law. I repeat myself. Land law is a statute law. It is a statute law in the sense that there is an act of parliament that regulates it. In fact, the courses you are doing this semester, the two prevailing statute laws are the land law and the criminal law. The land law and the criminal law, they are called the statute law. So you have to put it at the back of your mind that you make sure to grab a copy of the Land Law Act 2020 at 1036. Land Law Act 2020 at 1036. Whether you like it or yes, from today, make sure to get a copy. Again, from today, you must be able to know the Land Law Act, like the name. It is Land Law Act, or it is Land Act. Simple, simplicity. Land Act 2020 Act 1036. I repeat, Land Act 2020, the year 2020. It was being passed in the year 2020. So Land Law Act 2020 at 1036. Land Law Act 2020 at 1036. At 1036. Put it at the back of your mind. Land Law Act, the year 2020. Land Law Act 2020 at 1036. That is what we are going to use. Even if we will quote some cases, it does not necessarily mean that land law is a case law. Land law is a statute law. In fact, the Land Law Act 2020 at 1036 has repealed a lot of laws, not less than 20 laws. And that was the question that dropped in the Makola entrance exams. The amendments, the changes that the Land Law Act 2020 at 1036 has brought to forth, or has given birth, so far as land matters or land issues in Ghana are concerned. It was a full question on its own. We will solve that one. Don't worry, we will solve that one. We will solve it. We will solve it. We will solve it. Because it's highly examinable question. You solve that one. So you, at the end of the day, you get to know that Makola is, and you can write some. So that is how it is. The scope of the immovable property in Ghana. That is the topic we are coming to treat. In fact, I've divided it into two. We are going to look at part 1 and then we look at part 2 later. My hope is that this lecture maximum will last for 1 hour. That is my expectation. 1 hour to 1 hour, maximum of 50 minutes, 1 hour, 50 minutes. Let us quickly look at some of the objectives, things we wish to accomplish by the end of the lesson. So by the end of the lesson, we are hoping to be able to introduce the topic in our own way. In our own way. If we ask you, about the scope of the immovable property in Ghana, what are you going to say? Again, if we tell you to explain the term land, will you be able to do it? Initially, some of you were owning land, but you didn't know the meaning of land. Even land law, you didn't know what it is actually about. So by the end of our lesson today, we are hoping that we will be able to explain the term land. Again, we should be able to assess biblical view of land. If we are talking about land, don't forget when the Philistines, in the days of King Saul, the first king of Israel, from the tribe of Benjamin, when the Philistines were oppressing them, they wanted to take their land from them. Judah, King Jehoiakim, Zedekiah, Josiah, Prophet Jeremiah's time, Nebuchadnezzar, the son of Nebuchadnezzar, came to capture the land of Judah and Jerusalem. It was all about land. Land. It was all about land. Not forgetting this, we could also cast our mind back to the book of Genesis, where Abraham was being told to move from his family, his kindred, and go to the land that the Lord himself promised him to give him. Scripture says that the men of Abraham were fighting with the men of Lot, signifying that dispute over land didn't start today. It started from the Bible. We are not the first group to fight over land. So we will make sure to assess the biblical view of land. We'll make sure to assess the legal view of land, the legal perspective, how the law views land, how the law views land. We will also assess what the various learned authors have also said, or the views or the ideas they have expressed on land. We make sure to assess them accordingly. After that, we will try and see whether we could list some of the characteristics of land. And then we end with the concept of ownerless of land. Ownerless of land. When we say ownerless of land, what does it mean? In Akan, we say Pente Masasi Dahui and Nahokwa. The contemporary people will say Pinti Masase and Nahokwa. It is not Pinti Masase. It is Pain Masase. A land that is not bushy, a cleared land. You go and see a land which is cleared, then you think it is there without an owner. So you look at ownerness of land. For you to be able to get this right from the beginning, let me pay respect of 30 seconds. Respect of 30 seconds for you to look at this. 30 seconds respect. Let us pay it to Land Act 2010 at 1036. With all due respect, Let us be silent. All right. Our 30 seconds is over. So our respect to the Land Act 2020 at 10:36. You must never forget it. Almighty. Write it behind your door. Write it on a sheet of paper and paste it in your washroom. Write it on a sheet of paper, paste it at where you brush. Write it on a sheet of paper, paste it at where you normally sit, or near your dining table, even your kitchen when you're cooking, so that you could be watching it. Land Art 2020 at 10:36. You dare not forget this. You dare not. At the moment you forget, it means that you have failed the course in advance. So you dare not forget this. From our objective, number one is the introduction. We are going to treat the objectives seriatim, chronologically. That is what I mean, in order. So when we talk about immovable property, the study of the law of immovable property covers the land law. It covers the land law jurisprudence. In law, when you say jurisprudence, we are talking about the jurisdiction of a particular law. Jurisdiction, the scope. What is the scope? What is the jurisprudence? What is the area that it covers? The land law issues in Ghana here cannot be extended to that of Cote d'Ivoire. So the jurisprudence of Ghanaian law falls within the four walls of Ghana. So we are saying that the study of the law of immovable property covers the land law jurisprudence of Ghana and the analytical examination of laws covering lands in Ghana. The study of the land of the law of immovable property covers the land law jurisprudence of Ghana and the analytical examination of laws covering lands in Ghana. So you see that covers the land law jurisprudence of Ghana, underline Ghana, and the analytical examination of laws covering lands in Ghana. So even if Ghana, we have a land in Cote d'Ivoire, we can't say that, oh, Ghana, we own a land in Cote d'Ivoire, so we can extend our Act 10:36 to cover the land that we own at Cote d'Ivoire. That is impossible. It means impossible plus cannot is impossible. So the Land Law Act that we are using now, 10:36, covers the land law jurisprudence of Ghana and the analytical examination of laws covering lands in Ghana. It has repealed a lot of laws, conveyancing laws, a lot of laws, leases, mortgages, a lot of laws. Now it has become the supreme act that is governing the laws of Ghana. Who has his land law act very close to him or her? That person could open it to the first page and read something for us. Yes, please. Let's try and take something before. All right. So when you open it, where the coat of arm is, please kindly read it for us, Madam. I think, Madam, I think, Madam, Yes. So, Madam Abigail, please kindly unmute yourself and then read it for us.
We have Republic of Ghana.
Okay.
The 1036 Act of the Parliament of the Republic of Ghana, entitled Land Act 2020.
Okay. Move on.
An act is to revise, harmonize.
Please listen to me carefully. Listen to her carefully. Every act that you pick, if you want to know the aim, the purpose, the vision, the scope, the content, the jurisprudence of that particular act, open to that section. That page where the coat of arms is, it is giving us the purpose of the act, the goal of the act, the general title of the act. So, Madam Abigail, start it all over, because I don't want to interfere. I want you to finish reading it. Yes.
All right. The 1036 Act of the Parliament of the Republic of Ghana, entitled Land Act 2020. An act is to revise, harmonize, and consolidate the laws on land to ensure sustainable land administration and management, effective and efficient land tenure, and to provide for related matters. Date of assent, 23rd December 2020.
23rd.
Passed by Parliament and 23rd December 2020.
2020. Passed by Parliament.
Parliament and assented to
by the President. Good.
Yes.
So
appointed to by the President. Sorry.
Good. So that is how it is. Under constitutional law, I will teach you the process that it goes through before we get this. The process it goes through before we get this, specifically from Article 11. Article 11. In fact, from somewhere, Article 11, let me see, from clause 7 going. Clause 7. Article 11, clause 7 going. But what I want you to know is this. This act, in fact, the land issue, let me say the land law or the land related matters have become one of the headache of Ghana for so many years. The reason being that in those days, anytime they want to code laws and then rules for you to, let me say, govern it, then you see the kings, the chiefs, these people will be rising up. They will say that the land belongs to us. It belongs to the paramount chiefs. It belongs to the chiefs. It belongs to the kings. You know all these stuffs. It is a stew land. It is a skin land. It is what land? It is a family land. And my parents, our parents, grandparents, our ancestors fought for us. And so it was something else. Land matters. So there were a lot of laws before you could buy land in Ghana before the year 2020. The challenges that you go through, the documents you have to read as a lawyer before you be able to assist someone. You have to go and read this one, Conveyancing Act. You have to go and read this act. You have to go and read this act, Mortgages Act, Leases Act, then Act, this is Act, this is this Act. So if you look at one of the aim, so now we are picking one after the other before we zoom. The aim is that this act, what? Madam Abigail?
Yes, sir.
It what? It revises.
It revise, harmonize, and consolidate
Number one, please take your time. Number one is to revise. So the Land Act 2020 at 1036 has revised all acts that are in relation to land. Next one, to harmonize. Harmonize means that we're having several acts, different. If you want to embark on tenancy agreement, different acts. Conveyancing, different acts. Leases, different acts. Mortgages, different land. I hope you are getting it.
Yes,
different matters. So this act has harmonized. Next one.
And
Consolidate and consolidated. All
the laws on land to ensure sustainable land administration and management.
So if you want to prove to your colleagues that I understand the law, you can have this one in your mind, though it is not necessary. You can have this in your mind. The 1036 Act of Ghana is there to revise, harmonize, and consolidate the laws on land to ensure proper administration and management of land of Ghana. You can paraphrase. So understand it. So you are saying that the study of the law of immovable property covers the land law jurisprudence of Ghana and the analytical examination of laws covering lands in Ghana. It also covers the study of various principles and rules applying to immovable property. So you must know that the land law, the act you are holding, also covers the study of various principles and rules that applies to immovable property. So that is how it is. It is the intro. The intro is trying to let us know that when you pick the Act 1036, or when you talk about immovable property law as a law or land law, it is talking about issues relating to land. So the law on immovable property in Ghana is largely made up of Ghanaian customs and traditions. Don't forget, land matters are typically traditional matters. They are typically traditional matters. They are typically traditional matters. So the law on immovable property, the law on immovable property in Ghana is largely made up of Ghanaian custom and tradition. The common law of England and the doctrine of equity, which is applicable here in Ghana. Common law of England is applicable to Ghana because we were being ruled by these people. We were being colonized by these people. So they brought their common law to Ghana. And that is what has been in existence up to now. If the acts of common law nations, Ghana is one of them. Ghana is one of the common law nations. You must put it at the back of your mind. So for the purpose of our discussion, we are going to make good use of the Land Act 2020 at 1036, as well as the 1992 Constitution of the were you not hearing me? Hello?
Yeah.
I think we lost you briefly.
Oh, sorry.
Isn't
that okay?
Yes, please.
Please.
It is.
Okay. All right. So, like what I was saying, we are going to make good use of, respectfully, let me project my screen. So we are going to make good use of the Land Act 2020 at 1036, as well as the 1992 Constitution of the Republic of Ghana. That is what you are going to use. Let us set the ball rolling with physical property. When we talk about physical property, it could be grouped into two. Physical property, it could be grouped into two. Number one is the movable properties, and number two is the immovable properties. We have movable properties, and then we have immovable properties. But for the purpose of our discussion, we are going to focus on immovable property. When we talk about movable properties, what do we mean by that? Movable property. We are talking about assets that can be moved from one place to another. Assets that can be moved from one place to another. Examples are shares, bonds, deposits, which could be easily converted into cash. They could easily be converted into cash. What therefore is immovable property? Or immovable property talks about assets that cannot be moved from one place to the other without causing damage or destruction. So even in accountancy, we have what is called I have forgotten this one in accounting. We capture that one as a substantial cost. A substantial cost. Demolition. Cost of demolition. Cost of demolition. You see banks renting an apartment, and then when you go there, the way they have decorated the place, the way they have divided the place, it looks like they are not going to leave the place. They have bought the house or the building. It is part of the clause that when they are living there, they will dismantle all their items and then make sure to bring the place back to its original position as how they came to meet it. It is for dismantling cost in accounting. So we are saying that immovable property, you can never move it without causing danger or destruction. You can't just say that I want to move my land to UK because I'm traveling there. No. So that is how it is. Examples are houses and land. So let me respectfully shift my attention to immovable properties because our land law itself focuses on immovable property, because for the shares and then the rest, it belongs to the financial institutions. Let us leave them for them to talk about it. All right. So quickly, let us look at immovable property. We are saying that some categories of items may be seen as movable, but may have become so attached to the land that are regarded as part of the land. Yes, when we see a building, probably it might have been movable property as compared to land. However, the way building is being attached to land, whether you like it or yes, you cannot use aboboya or plagia to carry even one single room, let me say bathroom, to carry your washroom from where you are staying to another place. You can't do it. So we are saying that, yes, indeed, we have some items that could have felt under the category of movable property, but we cannot confidently call them movable property because they attach themselves strongly to land, which is immovable property. So what should we do then? We therefore conclude by saying that all those items are also supposed to be regarded as a land. So that is how it is. So there are items that are movable, but they have become so attached to the land that they are regarded as part of the land. If this being the case, then we are saying that they must be considered as immovable property. Why? The reason being that they are fixed to the immovable land. They are fixed to it. So their legal or technical term is called fixtures. Fixtures. So what we are trying to explain is captured in a Latin maxim or Latin principle called quid plantator solo sidit. Quid plantator solo sidit. Quid plantator solo sidit. It means that whatever is fixed to the land becomes part of the land. Whatever is fixed to the land becomes part of the land. So something that is or become affixed to the land becomes part of the land. Therefore, title to the fixture is part of the land and passes with title to the land, provided you are buying a land from me. And then you have bought it, you have done all the documentation for you. Later on, you have realized that there is gold on the land or there is oil on the land. Could the previous landowner come and say that, I only sold the surface of the land to you, I didn't sell the underground to you? Will you accept that assertion, Mr. Evers? Will you accept that assertion?
No, I wouldn't, because if I had not discovered oil or something gold on the land, would you have come back to tell me that you sold just the surface to me? I'll not accept it.
Well, fine, is because you have discovered it. That's why the person has come. So, are you going to compromise and just say that, yes, you were initially the landowner? So, anyway, I understand. Probably it's because of you that the oil or the gold develop under the land. So, are you going to accept that,
No.
Madam? Yes, you're not going to accept that. That is your side of the story. Okay. Mr. George, are you going to accept that? If yes, why? If no, why? Mr. George.
No, please.
Why are you not going to accept that?
Because land is sold to me with everything on it. For example, the grass on the land is also part of the land I bought. Just like the trees in the land.
Oh, okay.
So if you cannot come to me to say, well, the grass are not sold, are not part of the grass on the land is not part of the land I bought, then you do not come to me to say the gold I found on the land is yours.
Okay. If this is what you are saying, then let me try to pull your legs as a legal person. If this is what you are saying, let me try and pull your leg. So, Madam Anita, make sure to leave your comment with me. I want to get to know the position of your mind now. So kindly send it to me. Now, Mr. Edu, my question is, they are saying that if an oil is being found beneath the earth, then that one, the previous owner cannot just come and say that it belongs to him or her. It belongs to him or her. Previous owner cannot say that. That is fair deal. Let us behave as if that is right. If a gold is being found beneath, the previous owner cannot say that. Though the previous owner sold the surface of the earth, but the beneath is part of it. That is the assertion they are trying to bring on board. Then, Mr. Edu, my question is, what about the sky? The sky, the area above the surface of the earth, the sky. That one too, did you buy it as part of the land? Mr. Edu?
Yes. I believe a substantial part of the sky is also part of the land. Because the land becomes unusable.
Substantial part of the sky. Substantial is underlined.
Yes.
When you are done, I will ask what
Yes.
the substantial meaning per your definition of substantial.
Yes. Because the land may not be usable if there's no reasonable space above it.
Okay. I like that.
Yes.
Madam Anita, I'm waiting for your comment. The sky, Madam Anita, the sky. Does it belong to the person the new person who has bought the land? Okay. So, Mr. Edu, you were talking about a reasonable sky limit.
Yes.
Good. Now, Madam Akufo, please can you mute yourself? Good. Mr. Edu.
Yes, sir.
What? Okay. Within the context of your explanation, what does it mean to say reasonable or substantial?
Of course, there's I see every country has got some space above it that they take some sort of a sovereign authority over in relation to airlines and perhaps other purposes. But there is also a substantial space above lands that belongs to individuals, which they can perhaps use in extension of their properties they develop on their lands. For instance, if someone decides to mount a billboard on his land, it should extend above the land on some reasonable height or space. And for that matter, the person is permitted to use that space for his whatever he wants to use it for.
Okay. Madam Anita, kindly copy from there and paste it in the chat on Zoom chat, so that your colleagues also could read it. So kindly copy the comment you sent and paste it in the chat box on Zoom, so that your colleagues also could read it. Yeah, someone called my name.
Yes,
Mr. Edo, let me first
yes.
applaud Mr. Edu for his deep insight and comment. Yes.
I was about to say I didn't understand what he said.
I
didn't understand what Mr. Edu was saying.
What Mr. Edu was saying?
Yes, please.
What he is trying to bring on board is that Yes, every country has a substantial sky limit to claim as part of its property. Because not long ago, when there was an issue in, I don't know whether it is Mali or so, they try to block all entrance to their country, all airline entrance into their country. The same thing could happen here. When there's an issue in Ghana here, we can block our airline entrance. As how Ghana has a border with Ivory Coast, so far as land is concerned, Ghana also has a border with Ivory Coast, so far as the sky is also concerned. So he is trying to bring on board, trying to reason that, fine, the country has a sky limit, reasonable one, of course, so as the individuals, the civilians, the citizens also have a reasonable sky limit, of which I agree with him. I agree with him 100%. Because if the individuals, good. So Madam Anita is typing in the chat box, so you can be reading it. Madam Tiwa, you read it for us. You will read it for us. I want to involve each and everyone so that we move on. So that is exactly what he has said. If we don't have a reasonable space in the sky, then there won't be any need for us to build story buildings, or we can't even build story buildings. So each and everyone has a reasonable limit in the sky. Then let me ask this question: how many of you have seen this this camera? How do we call it? The camera they normally throw into the sky.
A drone, right?
Drone.
Okay.
Yes. So if I throw my drone into the sky and then it moves into someone's land sky, could that person send the issue to court? That is another issue.
I think that's a temporary action. The drone will not be in the sky forever. It's a temporary something. Yes, please.
Oh, I see. A very lenient lawyer.
They could take the person, like they could arrest the person. Because if it's once, you probably should warn the person. But if it's
the person,
if it's continuous,
I see. All of you are lenient lawyers. you should warn the person. Oh, I see.
I think intrusion into someone's privacy.
Okay, someone is also talking about someone's privacy. Anyway, you understand it much more under the law of tort: trespass into property, trespass to chattels, trespass to persons. So we will look at it, we assess it. God willing, our next lecture on land law, we will make sure to assess a very popular case on this. We will assess it. We get to know someone who mounted a billboard. The person mounted a billboard in his house, and then a tiny part of the billboard extended to someone's land in the air. And then it became a big issue. The same thing, we will try and see whether when you are orange in your house, the branches of it extends to the other person's house. What will be the implication? Law is interesting. When you are orange, that plant, that tree in your house, when the branches extends to someone's house, sometimes some of you who are in compound houses, or you could see that someone's plant will be, let me say 70% will be extending to your land, and it will be making your compound dirty. But when the fruit comes, then the person will claim that the plant is hers or his, and then he will be the one to be taking or to be plucking the fruit. And then when it is dry season, the dry leaves will be falling on your land. That one, when we move forward, you get to understand all this. Madam Akufo.
Yeah, sir, please. There was a question on board that if you buy a land from someone and later the person comes and claims that there is a good underground and he wants to claim ownership,
it doesn't belong to him anymore. It doesn't belong to him anymore.
Yes.
I want
the reason being that if you bought the land from the person, it means the person also bought it from the rightful ownership.
Okay.
And when he bought the land, did he say that the things underground belongs to those that he or she bought the land from?
Let me pull your leg as let me put your leg as a lawyer. The person didn't buy the land from anywhere. It was being passed onto him from his ancestors.
Okay.
What about that one? I hope you are getting it. So the argument lies.
But
I wanted you to apply. Very good. That is what I wanted you to apply. The quid plantator solo sidit.
Yes.
The quid plantator solo sidit. Very good. Sure. Anything that attaches itself to the land is part of the land. So if I buy it, I have bought it. If I buy it and there is cocoa on the land, come and take your cocoa away. If you don't take it away, it is mine. Except at the time of purchase, we enter into agreement that, oh, okay, because of that, I'm not going to take this amount. I had wanted to take 50,000, but because my cocoa will be on the land, I want to come down to 30,000. That one is agreement paid the two of you. Entity of contract, no one can interfere. To simplicity, we are trying to say that the owner of the land is the owner of anything fixed to it. Period. Hence, whatever is fixed to the land becomes part of it. Whatever is fixed to the land becomes part of its simplicity. Get to know this right from the start. Right from the start. So the introductory aspect, I think it is well done. So let us quickly analyze. Okay, let us quickly analyze what a land means. What a land means. What a land means. So section 46. Okay, someone has a question. Please, I will give you the permission for you to ask. So you can leave it in the chat box. Leave it in the chat box. Madam Tiwa will read them for me. I'll pause somewhere and take the questions. So leave them in the chat box. Section 46 of the current interpretation. Section 46 of the current interpretation Act 2009 at 792. 792. What is land? It defines immovable property as land. It says that immovable property means land. There are some definitions in the Act. I call them lazy man definitions. Sometimes I question them, especially criminal law. So the Interpretation Act, that's how it defines land. However, it must be noted that it is difficult to give a precise definition of land. A precise definition of land. Even the Bible did not define land. So in the beginning, God created heaven and earth. It didn't define it. So it's very difficult. It's very, very, very difficult to give a precise definition of land. The authorities at our disposal clearly show the inherent difficulties and defects in their supposed definition of land. Some of these authoritative definitions are going to be analyzed very soon. So We are going to analyze some of the authorities, people who have written, who have spoken, some of the legal perspective, biblical perspective, some authors, learned authors who have published books on land. All of them did not give the definition of a land, but they describe land. They try to talk about what a land is and what a land is not, rather than to give a clear definition of a land. Now, let me quickly finish with this and then take questions. What does the Bible say about land? You shouldn't forget that when we are talking about authorities in law, sometimes you could be speaking, but if you don't have an authority, you won't take it. So if someone asks you because you are freshest in law, that's why I'm emphasizing that if you are talking and someone says authority, it means that the person wants you to talk about a case, an act, or an accepted recommended book or acceptable recommended book. So if you can't mention any of them, then the case, you rest your case. You put it down and sit down. Because law, we deal with cases, we deal with authorities and evidence. So that is how it is. So in law, the Bible is considered as an authority source, since most of our laws were inspired by scripture. So it is well known that the same proponent of law, such as the natural law, view the law through biblical lenses. So this group of who have thought, they see the law to be something that emanates, that originates from the Bible. They are called the natural school of thought. And then one of these is Saint Thomas Aquinas. Saint Thomas Aquinas. Land is widely elaborated under the first chapter of the first book of the Bible, Genesis chapter 1, verse 1. In the beginning, God created heaven and the earth, according to King James Version. You see, it is authority. King James Version. It is an authority you can make reference to. So in the beginning, God created heaven and the earth. So what I'm trying to say is that it must be submitted that the verse talks about the originality of land under this chapter. So we could see that land came forth from God, who is the creator and the owner. So we can therefore conclude that exclusive title to land is vested in God, his creator. God is the exclusive, is the one who is holding an exclusive title. The one who is having an exclusive title. Then we are saying that it is therefore not in dispute that God is the owner of the earth and all therein. So God is the owner of land. We shouldn't forget. So that is how it is. Now let me chip in. We can therefore conclude that exclusive title to land is vested in God. God, the creator. All right, so that is how it is. Let me quickly pause here and take the question. So, Madam Tiwa, you can read the question to my hearing. Thank you.
Okay, please hold on. Please, I'm coming. Hold on. Okay.
So let's take the case, the question.
Okay. So the question from Madam Anita. Please, I heard of it where the landlord had a mango tree in his house, but before he grew it, The tenant put his tar around it, so the mango tree grew with the tar around it. The landlord had a problem with the tenant and decided to sack. So the tenant demanded for his tar. Will the tree be cut because of the tar?
Repeat the question.
So she heard of a case where the landlord had a mango tree in his house, planted a mango tree in his house. But then before the mango tree grew, there was a tenant that put a tar around the tree.
Okay.
So when the mango tree was growing, it grew and then it had the tar beneath, like around it at the bottom. Now the landlord had a problem with the tenant, so he decided to sack the tenant. But the tenant wanted the tar that he had put around the mango tree back. So in this case, so they have to cut the tree so that they can give the tenant his tar.
Very interesting case. All right. So this one, remember, we have something which is called discretion. I can give my discretions, however, when the fact of the case, after the fact of the case has been scrutinized or analyzed. Cases like this, the court doesn't become too litigant, like, oh, this. That is why we have remedies, appropriate remedies. We have some called compensation. We have some called injunction. You have some called specific performance. We have some called mandamus, cesurarai, co-waranto. All these are common law remedies. So there are a lot of remedies. There are a lot of remedies. The tie, could we convert it into money? So we give you money to go and buy one. Could we buy another one and substitute it? You can't just say, no, chin, 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 no, I want my tie. The court reasonably, because reasonableness is a friend of the law, the court could reasonably say that, oh no, we are not going to cut the tree. We are not going to cut the tree. So we will give you this amount and then you take it. Now, the tie, whether it is immovable property or movable property, immovable property or movable property. Now, when you look, okay, what is your suggestion? Let me, if not, it will be teacher-centered. What is your suggestion? What does the law say about land? Let us look at the repealed interpretation, the repeal, section 32 of the now repealed interpretation act, 1960. It gives the definition of land as land includes. English, when we use includes, what does it mean? Include. It means that we are talking about scope. We are describing it. We are describing it. Define land, you are saying land includes. Land includes land. No, you are giving us some examples or something else. Land includes land covered by water, by house, building or structure whatsoever, and any estate, interest, or right in, to, or over land or water. So that is how it defines it. Land includes land covered by water. So even land, water is land. If you have a river at your hometown, it is land. You can't just go into someone's river and then say, I'm going to catch fish just because, oh, it is God something. So no, it is land. Be very careful. So that is how it, as a definition from the repealed repealed the Interpretation Act 1960 Act 1960, Section 32. Also, under the English Law of Property Act 1925, land is defined to include any tenure, any mines and minerals, whether or not held apart from the surface. Buildings or part of buildings, whether the divisions may be horizontal, vertical, or any other way. So that is how it is. From them, that is what they are trying to say. It is good to have fair knowledge, but it is not important to chew them for this one. No. Get the fair knowledge, but they are irrelevant. Very important. So, Mrs. Okay, I'll come back to that when we are on break. So the common problem with the two definitions, when you look at the definition number 1, Section 32 of the now repealed Interpretation Act 1960 gives the definition of land law. Land law includes land covered by water, includes. It means that it's not giving a definition, it is describing. When you look at this one, the English law of property, land law is defined to include. It means that the common problem with the two definitions of land is that they do not define. All right, so the two definitions or the two words did not define land. Rather, they describe what land should be. So that is how it is. So the common law problem with the two. All right. So I think that is how it is. We have assessed that. Then we are on the 5th one. What does textbook say about land? So for the purpose of our discussion, I, Alexander Osei, wishes to bring this section to a close. Land law, to bring it to a close, or to bring it to a closer. Any question, contribution, suggestion is welcome. Yes.